Hello everyone. Welcome to this webinar on the future of user consent. I'm Romain Gauthier, co-founder and CEO of Didomi, and I'll be your host today. I'll have the privilege to welcome three that I call privacy heavyweights for this discussion. I'm really pleased to have with me today Max Schrems. I'm not sure you need an intro at this point in privacy history. But yeah, it's a privilege to have you as a part of these discussions. You're key stakeholders in many of the topics that we are going to discuss. So glad to get your point of view on all these topics. I'm also delighted to welcome Willy Mikalef from Bird and Bird, who will bring a wealth of expertise in privacy laws to the table, and who is also the only lawyer that I know who is passionate about space law. So for those of you who didn't know that, that's a key attribute of Willy. And yeah, thanks for joining, Willy. Last but not least, we have also the pleasure to welcome Peter Craddock with us. Peter is also a key stakeholder, not for the same reasons, but defending a lot of companies and organizations in many cases that we are going to discuss today. And I must say that your LinkedIn articles on privacy are one of my personal favorites. I suggest that everyone in the audience who is interested in privacy to have a look at these. They are really interesting to get to the bottom of some questions. We'll discuss a couple of topics today. The agenda is fairly rich, so we will not waste too much time to get the most out of it. Starting with the EDPB Cookie Banner Task Force guidelines. Moving on next to the payer consent discussion, and like closing the webinar with like some thoughts around privacy and AI. So a very rich and timely agenda. Couple of rules that I will share right away. So first, we'll start every section with a short summary by one of our guests of 2 minutes. Let's hope that we stick to this timeline, mostly to frame the discussion in an interesting way and launch the debates and questions. Next set of rules is it's an open forum, so you'll have access to the chat, you'll have access to the questions tab. Feel free to interact with us, and we'll use your contribution to feed the discussion. Obviously, there will be also 2 polls that will launch during the webinar. So without further ado, let's get started. Thanks all for joining. And as I said, we'll start with a discussion around the EDPB Cookie Banner Task Force guidelines. Willy, you have the privilege to start. Could you walk us through these recent guidelines on cookie banners, and what implications do you see for businesses, especially in terms of compliance?
Yes, sure. Thank you very much, Romain. Very happy to take part in this webinar. So on this first topic, on the topic of cookies and trackers, the European Data Protection Board issued 2 important publications last year. First, guidelines on the technical scope of Article 5.3 of the ePrivacy Directive, which is the legal basis for cookie consent requirements. And second, a report of the work undertaken by the Cookie Banner Task Force, which addresses for the first time at European level the question of dark patterns being installed in cookies. And we will focus today on this second publication. Dark pattern refers in this context to deceptive design and presentation practices to force users to consent to cookies. And the report, which has been published by the Cookie Banner Task Force, and it is important to say, does not constitute an EDPB guidance. Initially, this task force was created in reaction to the filing by None of Your Business of hundreds of complaints to 18 EU and EEA data protection authorities relating to the design of cookie banners. So it was also not adopted in the framework of the GDPR cooperation procedure, because the latter, as you all know, does not apply to enforcement of this article of the e-privacy directive, which relates to cookies. So this report addresses a number of practices which are listed on the right of this slide. And while there was hope from organizations that this document would harmonize regulators' expectations in terms of cookie banner design, well, the report does not contain much crispy content. Actually, the task force findings are rather general and often refer to a case-by-case approach. And for instance, the EDPB could not even find a consensus on the fact that the absence of a reject all button on the first layer is mandatory. So in the discussion, we will come back on certain examples and discuss this further, but this context is very important for you to understand why you don't get such crispy content in this document. And in this context, the impact for organization is that the application of cookie rules remain quite fragmented in the EU. And organizations, in fact, need to keep following the national rules and the regulators' guidance, which are more detailed, more precise. And as we do for other topics, Bird & Bird publishes every year a global cookie review, including a heat map of your risk in relation to cookies. And we keep observing varying situations and risk on key issues, for example, the lawfulness of cookie rules. And same for the enforcement. The enforcement varies from one country to the other. And I would say, and you can see on that slide, the different dots with varying level of risk, that countries like France, Germany, the Netherlands, Ireland, or Spain are probably those where the enforcement risk is the highest. Talking about a country I know very much, France, it is important to note that the French DPA fined companies a total of almost 500 million euros for breaches of cookie rules since 2020, and it should remain as an high-risk compliance area. CNIL just announced this morning a new wave of enforcement actions on mobile applications compliance with cookie and trackers rules starting next year. So despite this fragmentation, and in order to spark further discussion about the report of the EDPB, NOIB published itself a report which compares the task force findings and the positions taken by national DPAs. And as we have today the chairperson of NOIB, maybe Max, you could say a few words about this report.
Sure. Thanks for everything. So originally, we brought these cases exactly to get harmonization in Europe as well. So our thinking was, if we have cases all over Europe that are very similar with, like, we name violation A, B, C, we kind of structured that, that we would have very similar decisions at some point and force the EDPB to some kind of agreement. And it's interesting because we brought them largely under GDPR, not just e-privacy, because we basically brought them under both, and some regulators are in charge of both. But we also just, usually just did GDPR to make sure that there's this cooperation mechanism. And we were surprised that there's going to be a task force, which I think the GDPR does not foresee in any way. It's an informal, let's get together and have a coffee kind of format. Which led to kind of these different results, and we're still extremely fragmented. And my favorite part of the EDPB report itself, there is one point where they have a list of 1 bullet point. So you could totally see that they agreed on 5 bullet points or tried to do that, and then deleted one after the other that they couldn't agree with, until you had a 1 bullet point list, which I think I've never seen otherwise before. And I think what it speaks to largely is still this situation where Some DPAs, and we kind of know usually which ones because we can compare it to their national guidelines. Still, like for each issue, there's still one that resists or so, and they couldn't really get to a majority view or something. And so it's basically, I think the EDPB guidelines, and the bottom line is kind of the absolute rock bottom threshold. Like that's the only thing that they all could agree on. But then if you go into the national cases, and especially the cases we run, about 600 or 700 of them, usually the enforcement goes much further. So the only one where we largely see that they do not enforce it is the as easy to withdraw as to give consent, which interestingly in the law is very precise. Like the GDPR explicitly says withdrawing consent has to be as easy as giving it, which means you would have to have a permanent withdraw button if you take it literally, because if you have a permanent, accept button, that would be as easy. And we said there should be at least a hovering button or something that is permanently visible. And that is something where the DPAs so far say, yeah, if there's some reject button in the bottom of the page, that's good enough. I don't know if that's going to survive if it goes to the Court of Justice or so. Like none of these cases has really gone to the Supreme Courts. But that's the one where we see that there is resistance. For most of the others, we see actually that they agree that you can't have, I don't know, obnoxious colors, or that you can't actually have the reject button on second layer. I don't think we have a single case where a DPA actually in practice has said a reject button on a second layer is okay. So it's very hard to navigate, because if you just read the report, you get the impression that a lot of stuff is kind of acceptable, that if you actually bring a case, they then actually don't accept again. So it's quite unfortunate, to be honest. And in the report, it's free on our website. You can download it. We try to summarize per country, the cases we had and what the results were in actual litigation. So if that's useful for people, you can find it on our website. And there's also a overview tab where you can see like red, green, and so on.
Thank you, Max. We have actually like an interesting question in the chat about like going cookieless, which is clearly a core trend that we see in the digital space, where people are moving tags from client side to server side, and resulting in less cookies being dropped, even like no more cookies being dropped, and the whole data collection system being changed. Like, are these like reports and opinion a thing of the past, or like are they already outdated? Do you think they are any helpful at this point in time for anyone interested in the topic?
I think from our side, for example, we have done cookieless since we started our stuff as far as possible. Obviously, for some parts we can't do that. And it may be one opportunity if you're, for example, not doing a lot of advertisement, and if you don't need like third-party integrations where some cookies may be just like effect. So I think it's for us, for example, a solution, but I guess for many others not. But that's for, I think, everybody else in the room to know a bit more about what technically is really necessary in each case or not, or also economically.
Thank you. And Peter, when we prepared this session, the term dark pattern triggered an interesting discussion. How would you frame the notion of dark patterns from a legal perspective at this point in time? Like, what's the framework that is helping like your clients make useful decisions outside of these reports?
Well, ultimately, with dark patterns, a lot of the discussion has been focused on the idea that some kinds of behavior, some kinds of user interface is misleading. And I know I might be slightly controversial when I'm saying this, but basically all interfaces that we're interacting with are misleading to some extent. Everyone wants to sell. So every supermarket you enter it, I always use that example because I think it's a useful one to make things visual. The most expensive stuff is at eye level. That's normal. It's because they're trying to sell one particular version, ideally above something else. And so being able to promote certain options in a certain way isn't per se illegal. And so a lot of the discussion then relates to this gray line between when is something misleading, when am I robbing someone of their choice, and when am I just trying to influence their choice. And I think there's a very large set of cases right now where the position has been this is misleading, when in fact the discussion should be more, is it purely influencing? And so I think there's a lot of room for discussion still in relation to dark patterns, because ultimately you have a choice, you have autonomy. And so a lot of the discussion seems to circle around what is this notion of freely given consent? When do I lose this freedom? When am I robbed of this freedom? And that ultimately is what is going to lead to a lot of cases, I think, in litigation, but also discussions among stakeholders from different groups, trying to come up with frameworks, codes of conduct, rules within a sector, within a practice. And I think there's a lot of room for discussion still today. And we don't necessarily always have to think about litigation. Obviously, I'm a data litigator, so when my clients are faced with litigation, I help them. But ultimately, what I like them to have is a solution. And I think a lot of the discussions we're having right now regarding dark patterns are based on basically just ideas of, I want to say, kind of absolutes, that it's either or, it can't be somewhere in between. And that's just not right. I think we need to find solutions that are somewhere in between. It's like the colors. I like to use the example of colors as well, because, well, if there was recently a decision that's been referenced in the chat, and one of them was that there was an option of accept that was in dark red. And that was seen to be a dark pattern from a color perspective. And that's because the other option was in gray. Now, gray obviously is a bit of a murky area. There's a lot of discussion about whether that is something that should be done. But dark red is typically the example that a lot of companies have been told, don't use that because it's a psychological negative. And so people are going to avoid it. So I think you need to have more in-depth discussions regarding this, regarding dark patterns, regarding the choice of color, and basically the fact that sometimes branding is allowed to be used. I'm not saying that you're basically, it's either this or you lose all your data and you don't have anything, because I think some of these discussions tend to veer very quickly into oppositions of extremes. I think we shouldn't do that. We should get to the ground level of what is the legal discussion. And the legal discussion is, do I have a freely given consent when someone is presented with 2 options or 3 options, and one of them is in a color that is different compared to the others? And that's not the same as saying, I don't have a choice. So I think it's really important to always get back to these discussions about the fundamentals.
If I may chip on this for a second, I think what's missing here largely is we have evidence for that. Like, it's not a discussion, it's not just viewpoints. We have numbers on which pattern is, changing people's behavior. And it's not uncommon law that we, let's say, limit what companies can do to influence people. Like in Austria or Germany, there is the Kaffeefahrt, which is getting a lot of like old people into a bus and then basically selling them blankets and I don't know what. and we gradually outlawed that because we realized, okay, people come back with 20 blankets that they actually never wanted, but in a psychological situation where, that the trip was free and they got coffee for free, suddenly people have an urge to buy blankets, and that's highly deceptive and was outlawed. And I think we're somewhere in that ballpark. I agree on that, where we can see of what changes. And what's really interesting is if you look into tons of studies on behavioral economics and so on how people decide in which situation. And cookie banners is a typical thing where people do not take a decision, a real decision. If you go to the supermarket, you at least look at the price usually before you just grab whatever there on the shelf. And we know for cookie banners, people click so fast they cannot possibly have read any of it. And we also know each element that you can add, and that's also what we brought in complaints. How much the percentage goes up of a consent rate. And if we know that people say something like, usually we get the numbers between 3 and 10% of people actually want to consent to it, but you end up with a 90% consent rate because it's so obnoxious to say no that people just give up, then I wonder how much we still have to freely giving consent. And the GDPR may be also a bit different in that to contract law, which is definitely more liberal, that you have to have a fair interaction under Article 5.1, you have transparent interaction and so on. And that is, at least I can tell you, like Austria, more than we have in a lot of the contract law. So I do think that there is a bit more, let's say, duty on the side of the company than the average supermarket. And even there you have, duties to, I can, at least, again, civil law is very different, but in Austria you have duties that, the prices are, of a certain size, people can actually read them, yada, yada, yada. You have to have a price on each product, not on the back, but on the front and so on. So we do have these transparency rules as well to make choices easy for people somehow, and to really protect what they really want, so to say, ideally. So I think I agree that there's some gray area, but it's probably, sometimes a bit more nuanced, let's put it that way.
It's interesting. We have a point of debate between opening up creativity for UX UI and setting up the right boundaries to avoid the deceptive design. That's a tricky one. I'm not sure. I think the law can really be helpful, because creative people will always find a creative way to do things a bit differently. So you can't put that between large principles. I guess it's where these attempts are usually failing. In any way, I think it would be helpful if we would have eventually a set of principles that everyone could refer to and put in place. That would help, I think, everyone at this point in history. Okay, I think time is going fast, and we have also people already eager to hear you on the consent or pay model question that was raised in the chat already. So obviously, as a consent management provider, we are kind of key stakeholder in these debates. A lot of publishers are relying on our technology to power these models. They call that paywalls, cookie walls. I think people misunderstand the way we work in this context. As a technology provider, we are mainly neutral, so our clients choose the feature that they implement and the way they implement them. So some argue that we can't be completely neutral, but still our clients are paying us for just the technology, not choosing the setup on their behalf. So obviously it's a heated question, so that there were lots of debates before the summer and over the summer with respect to this question. Maybe Max, in 2 minutes, could you walk us through from your standpoint where this comes from and where do we stand at this point in time? And I put a brief timeline on the screen for those less familiar with the concept.
Yeah. Cool. Yeah. So on the PRK, it's maybe useful. I would extend the timeline about 5 years prior. The first one we came across was actually a liberal newspaper in Vienna, where they started this PRK thing the first time I ever saw it. And it was quickly approved by the Austrian Data Protection Authority with I think a 2-page decision or something, not even. And the argument was basically back then, if you have a printed newspaper, that's 42 euros per month. So if you now have a banner, so to say, and I think at the time was 8 euros or something, it's cheaper than a printed newspaper. So hooray, that's the decision. And what was a bit missing was some of the background story of this. What happened then is that it gradually went into Germany, then it went into, I think, France gradually. Now it's in Italy and Spain as well. So we have some of these countries that actually, where newspapers started this whole discussion. And what we have one case in Hamburg as well, where there was simply no investigation. These cases simply got decided without ever looking at the economics of it, ever looking at the consent rates of it. None of that was ever done in these investigations, which is extremely worrying because we usually bring this up, but then the regulator just goes ahead. Now, the reason that we all knew why this is happening is it's newspapers. They just don't want to ever touch the news media, and that's informally what you also hear. What was interesting is that, and that's what we argued for years, is that if that's accepted, Meta can do it as well. Everybody else can do it, not just newspapers. The GDPR is not specific to news outlets versus other websites. Guess what? Meta has done that. And that was partly based on this Court of Justice ruling that's on the slides now. The Bundeskartellamt case is a extremely convoluted case. I think it had 20 questions or something in the reference. And what's interesting is, as far as we know, no one has brought up PRK in the litigation itself. So it must have happened that at the end of the litigation, some judge of the 15-judge panel has added these 6 words of, or whatever, I think it's 6 words of, or against a reasonable fee. That was now especially relied on by Meta to say, okay, we can just charge a fee. What we would differentiate a bit is that the whole section talks a lot about the genuine and free choice. So it's like 5 times or something that they mention you genuine free choice, really what the people want, yada, yada, yada. And then it's one option where it says or against a possible fee. So we wonder how much it's a like just you can do it and we're good here now. Also, to put some context into that, we had a court hearing in January, also at the Court of Justice, where the judges were extremely interested in PRK and asked a lot of questions. It was not about that. So you saw that for them, it was not a done discussion. They were still very much interested in this whole discussion. Now, what now happened is the EDPB consent or pay opinion, which in my view is highly political. They list a couple of reasons why basically Meta or large online platforms can do it. One of them is, for example, the network effect. So the idea is because you have to go to the website because everybody else is there, that's kind of different for your freedom of choice than a normal news website. Now, getting back to the discussion we just had before, and maybe connecting that a bit, we know that, again, like 3 to 10% of the people really want to have advertisement. Usually depends on the study and what's really asked. And we know that for a pay or K system in the litigation that we have a 99.9% consent rate. So I usually call it the North Korean consent rate. And it's kind of at the absolute end of the discussion when it comes to the, I think, legally relevant part, which is freely given consent, in the sense that that's really not what people want, but they're not going to pay like 10 euros per page to be able to click a reject button. We usually call it like the reject button fee. And it's especially interesting if we compare it to the EDPB decision in the dark patterns, because, for example, putting a reject button on the second layer apparently is a no-no, but putting a 10 euro fee on a reject button is an okay. So I think if we put that next to each other, it's going to be hard to argue. What I'm especially worried is this very political approach that the EDPB is taking here, because we know that as far as we know, Meta does not have a higher consent rate because they are a network than a normal website. People just do not reject if it's a PRK system. So we wonder if the EDPB is not just basically trying to cut out exactly Meta factors without really having evidence for that. And I think that is where we really need to go into more to look at hard evidence for PRK. What are the factors that influence people? How are they working? We think, for example, stuff like you have to type in a credit card. It's just a lot of friction compared to just clicking a accept button, may be a factor independent of the money itself. Last but not least, if you look at the financials, which is the main argument on the other side, is to say we have to finance all of that and so on. It's quite interesting because in all the litigation we had so far, we know that most of them make like 4 cents, 10 cents per month with like a user that consented. Depends extremely on the numbers, but like somewhere in that ballpark. And for one of the cases that we litigated, we know that they basically overcharge 200 times. So if you pay for it, you pay about 200 times more, which was about 10 euros in this case, than what the company is actually making from advertisement. So even this argument that it has to be a fair economic balance, and if you don't, accept, you have to kind of somehow else chip in, then chipping in would be a couple of cents and not paying 10 euros. And if you talk with newspapers, especially in the background, it's very largely an argument to say we still want to actually make money with subscriptions, not with advertisement. Subscription is the one that we really want. And it's a good segue into subscription. So you basically take a quickie banner and make it an advertisement space for subscriptions by, taking the reject button and basically make it a subscribe button. And then you bundle 2 different types of revenue sources. in a way that, let's say, the GDPR has not really foreseen as an option. It's usually not a consent or subscribe option, but it is a giving up of your fundamental right to a certain extent.
Thank you, Max. That's a full overview of the case. I'm sure Peter has some reactions to that, because when we prepared the session, we clearly have some opposite arguments there.
Well, of course, no, but the key thing with consent or pay, in my view, is that we have to differentiate first two things. Are we talking about the opinion of the EDPB, or are we talking about something else entirely, and the validity of the business model as a whole? Because when we look at the way things have been happening, there's been basically at the level of regulators, there's been generally an acceptance of the consent or pay approach until we had the EDPB opinion that suddenly was saying, well, for large online platforms, whatever that means, then suddenly basically this is no longer okay. And there's a huge amount of uncertainty regarding this, regarding basically what on earth these large online platforms are. And so the EDPB has then said, well, we're now going to do our guidelines, we're going to do a pre-consultation, which from my discussions with people seems to be the fear that it's purely going to be a Zoom meeting and that's going to be it. There won't be a real opportunity to provide feedback. So basically, what are we doing? Are we just going to have a repeat? Or are we going to have some questions now, a bit of question marks regarding, well, when is pay-OK actually accepted? Because ultimately, a lot of the arguments that we see depend on who's making them. And we see very often from the side of regulators and of some non-profit organizations, we see a lot of, well, this is about you're selling your fundamental rights. Is that reject fee idea that Max, you were mentioning. And I think that's a very unfair comparison, because it's like saying, well, sorry, I'm a bully and I'm coming and I'm going to force you to pay me because otherwise, well, you can't use it. Well, sorry, but services are commercial. And initially, every service is there. Every service that is being offered by a non-profit company, a for-profit organization, is basically there in order to be able to provide it. They need funding. And that funding is through different means. And so you choose your business model. And for ages now, we've tolerated a way of working, a way of funding the internet. And now suddenly we're going to say, well, actually, personalized advertising, we're against it. We're against it. We're not going to give a real reason why. We're not going to give a legal reasoning why we think it's bad, but we're going to reject it. And so we're going to force you to go down another route. And that other route, well, we're going to say that only that large online platforms can't use it. They have to offer a free alternative. And that free alternative is suddenly with some general idea like generalized advertising, which doesn't make any sense, or contextual advertising, which doesn't work for everyone. So there's a lot of problems there, I think, with this approach by regulators. And I think we have to go back to the very beginning of the question. Is personalized advertising lawful or not? And so far, no single law has outlawed it. And the only thing we've seen is that the law has said specifically targeted advertising vis-a-vis children is unlawful. Targeted advertising based on sensitive data is unlawful. We have specific legislation about that. But nothing that says personalized advertising as a whole is unlawful. And so I think the problem is that the whole debate is based on a premise that is flawed. And I think this is the biggest problem, that we're getting into these debates based on the fact that we're presuming that personalized advertising is lawful without actually understanding how it works. Regulators do not understand personalized advertising. I know I've been litigating cases on personalized advertising, and then there was, for me, the brilliant opening of the case before the Court of Justice regarding the transparency and consent framework with the authority, the Belgian Data Protection Authority's lawyer, saying, "I'm not going to say that your phone is listening to you, but these are all myths. These are myths that need to be busted." but they're at the very origin of this entire discussion. And I think that is a problem. So I think the discussion regarding consent or pay is a really important one. But first, we need to fix the premises of that discussion, because otherwise we can't have a valid discussion regarding pay or okay if we're going to presume that the personalized advertising component is unlawful.
Just to add to that for a second, I don't think we have ever presumed that, and it's a wonderful exercise of reframing that you're doing right now. The real question is, you can have advertisement, but what is regulated is using personal data for advertisement. And that is what we call consent. And I think there is more than enough very explicit law for that. So it's not about banning advertisement, not advertisement, but cheers to the reframing.
Like zooming to the question of what is a valid consent in the case in the case of a pay or consent model. At Didomi, we measure things, so we do what we call consent analytics, and it's very interesting to notice that in every debate something is missing, which is how many users are actually bouncing, so leaving the website, so preferring to move away from the choice that is offered to them, which is another way to say no. And I think that's one element that is very often missing in the figures, also the figures that you're quoting, Max, because you can have a 99% consent rate, but still like only 56% of people actually opting in, because the rest has left the website for a long time.
And that would really be
and so that's where I think the debate is not really framed correctly, because there is always this option of leaving and refusing to answer the question the way it's framed, and that's the fundamental freedom of the internet that is never removed from the user.
That is the interesting part, that so far no one provided that number. In any of the litigation, people brought this argument up, but no one actually provided that number. And the number, we all know the bounce rate, like everybody has, like even we know the bounce rate on our website. And that's interesting, because so far there is really, these are elements where numbers are missing. And also the EDPB cannot make decisions without having these numbers. So it would be really, really interesting to get it like public and you know, to actually have that debate. So far, that's one of the numbers that is missing in all the reports.
Yeah, we actually looked at a question that we think is interesting, which is when presented to the, when you present the user to like a choice where it has to pay or consent, how much users will change their mind because they realize they are going to have to pay, and surprisingly, like a lot are changing their mind, so between 50 and 70%. But the concentrate, so the overall like volume of people who are actually ending up consenting to whatever purposes you declared, is not moving up that much. So like the average in Europe these days is probably around 56% of people actually consenting, opting in, and so you can move the needle by 5 to 22%. So you can get close to 80%. But you can still see this 20% of the internet who is very reluctant to having their personal data being used, and as a result, like leaving or opting out.
So not necessarily North Korea.
Right. No, I think that was one of my points.
It's North Korea without a border. That's what you try to say. It's like you can still go to the south.
Right. You can still go to the south. One interesting question that is very that is not often discussed is what Peter called circumvention. So a lot of users are starting to use methods, tools to block ads, to block trackers, to even block consent management platforms, and also to block the technology behind paywalls to unlock access to the free content. What's your take on that? From a legal and personal point of view, do you think that's the way to go to maintain a free internet?
I think, if I may first, and I'd love to hear the opinions of the others. I think ultimately this becomes a very important question, because a lot of the discussion on numbers of people who reject personalized advertising in particular and so on has been focused on percentages, but without making a difference between those who are rejected because they have an ad blocker and everyone else. And it's a really important discussion to have, because I've attended conferences where I heard people, sometimes brilliant academics, who are saying, use an ad blocker. And I'm thinking, no, that is not what you should be promoting. The point is, we should be promoting a solution that is lawful, because if I use an ad blocker, I'm actually in breach of your terms of use of your website. So I'm actually using your service illegally. And so that is something that we should absolutely avoid. If you have transparency, I know this is a very important point, and it's a fundamental point in any discussion, but let's move away from presuming that every website is bad at informing, and let's accept that there's a minimum level of information that we already have, and that we can have additional information from websites. But if we have a bit of transparency, if we understand that there's personalized advertising, then why am I basically should I be encouraged to use an ad blocker? Because then basically I'm encouraging people to do something that is against the terms of use. And I know we live in an age where we might have a discussion in a few minutes regarding AI, where again, there's that question of compliance with terms. But I think it's really important to have this discussion, to put it on the agenda, because ad blockers are basically saying to the publisher, I don't care. I'm going to get your content for free, full stop. And I think this is something that we should try to banish from these discussions as far as possible.
I may just 1 second, maybe that's different in the common law jurisdiction, but at least I can tell you in my jurisdiction, terms of service on a website would not constitute a normal contract. So that's all nice and beautiful what's in these terms, but at least you could not litigate that in Austria. But that may be a different story depending on the jurisdiction you're in. I mean, I haven't heard anybody that was ever, pursued for fraud because of use of putting up an ad blocker, which is kind of where this discussion is going. I find that quite extreme, but yeah.
No, but the whole discussion is about lawfulness, and I think this is important, because if we say, well, ad blockers are okay, then how can the same people then say, well, AI models that are being gathering information online are doing things illegally? Because ultimately, it's also about going around the content restrictions sometimes. So I think it's really important to bear that in mind, that you have to be consistent.
Yeah, but no one ever relied on terms of conditions to have privacy rights in AI. Like you have to be consistent, I agree, but you have to differentiate between statutory law and contractual law. And I guess as a lawyer, you're able to do that.
Maybe on this topic, I think that the bottom line is that this trend just make publishers' life even more difficult, and also on the pay or consent debate, what many of the people listening to us today, may have the question of whether this kind of prohibition of the pay or consent model set out by the EDPB in its latest opinion does apply to all publishers or not. And on this, it's important to remind that the EDPB opinion applies to large online platforms, so big players, which in fact is also, poses two types of issues: an issue of terminology, an issue of competence. So the term large online platform is not defined in the GDPR. It is, defined by the EDPB itself as platforms that attract a large amount of data subjects as their users. It borrows vaguely from the very large online platform term present in the Digital Market Act and the DSA, the Digital Services Act. So for the moment, the message of the authorities is that it does not apply to other providers than these, although there is no rigorous and precise criterion to determine which actors are in scope. And this also means that the EDPB is applying an asymmetric regulation to large online platforms, but without clear legal basis to do so. And we do wonder with what solutions it will come with when it will look at the pay or consent models of other providers. So all of this, unfortunately, and it's a message that we have to say today, brings a lot of legal uncertainty. in this discussion. And I mean, most organizations, unfortunately, have to navigate through this uncertainty.
Indeed, and maybe I will add to the list of things that bring uncertainty with this question. So EDPB mentioned a lot this idea of free alternative without behavioral advertising. Question, is there such a thing as a free alternative without behavioral advertising that works for the internet? Is it the role of the EDPB to frame it that way? Just launching the question because I think it's an important one, and the audience may want to hear you on this.
Well, the EDPB basically makes two suggestions. They talk about contextual advertising and they talk about general advertising. Now, the general advertising is very nice in theory. It's the idea of the billboards. The billboards on the highway. And I always say, well, a billboard on the highway, that's very nice, but you know that you've got eyeballs tracking it. You know, basically that currently it's mostly humans who drive cars. And so basically then it's easy because you can have counters, you can have cameras that count the number of cars. And so you can have an idea of how many people are coming. But general advertising doesn't work online because basically there is a massive problem with fraud. There is a massive amount of bots that are being used. There are basically bot farms that are being used to basically drive up click rates and so on. Just recently, there were a couple of videos still circulating about bot farms in China and whatever. Now, there is a fundamental issue there. And so general advertising just doesn't work. Contextual advertising does work. Contextual advertising does work, but it doesn't work for everyone. It works on certain properties. And this is something that has been seen over years, that the publishing industry in particular has been able to see this. A lot of information is basically, you can see how things have been evolving. You can see how advertising can be made relevant to the audience. Now, I see a question. How do you think stuff got advertised before the web? Well, that was simple. That was easy. You had books. You had magazines. You had readership. You knew how many people were walking down the street by looking. You were able to see how many books were printed. And so it was very easy. But on the internet, it isn't that easy. And so it's very easy to say contextual advertising is a solution. It just doesn't work for everyone. And that is an important thing that the regulators seem to be forgetting, unfortunately. They're taking business decisions based on incomplete information. And why is it incomplete? Because they're using mechanisms that basically mean that they could see that they just don't have any consultation. There's no time to have discussions, or they don't want to take time to take discussions. And that, I think, is a fundamental issue. We could have decent rules if regulators opened the door and had a serious discussion with stakeholders from across the whole spectrum, from civil society to companies. I think it would be really important to have that.
And I would add, to be on a happy note there, it would be great if people would also provide this data that they talk about, because that is our problem. We usually take a very academic approach to these things, but a lot of these arguments are not backed up with actual data. And there are, industry associations especially that would be best placed to actually put this number down. And then we can have that informed discussion. Right now, everybody's making arguments without the footnotes that go with it.
Like a positive note. Thank you for that. Okay, for the sake of time, we will have to move to the last topic, which is, I think, would deserve a webinar on its own. So I think the way we can frame that is to focus on the news, what's happening recently, what has been happening recently with respect to AI and privacy. Max, I think I think it was Peter who was supposed to introduce the topic, who has the role of presenting this topic in 2 minutes. So I will say good luck, Peter.
I'll try to take 1 minute, because I think we need to have a bit of a discussion on this. So we have recently had the announcement that the Irish authority had reached out to the European Data Protection Board to come up with an opinion based on this Article 64, paragraph 2 procedure of the GDPR. Now, the idea is that this is going to be an opinion coming from the European Data Protection Board on the issue of notably training of AI systems, and notably the interaction with personal data in particular. Now, I think it's useful to visualize things a bit. And so this is a very, very oversimplified sketch of some considerations that we have to take into account. Because from a user's perspective, when you're interacting with, for instance, a large language model like through ChatGPT or whatever system you want to use, well, you start by providing input, and then you receive output. But what happens in the back end that you don't see is basically the interaction with in this case, then a large language model, but whatever AI system you're using. And AI systems are based on training. You have to train an AI system in order to basically be able to lead it to work in a certain way. And the discussion that we're having nowadays is, what do we do with the training, in particular of LLMs, when it comes to gathering of information? And one of the key things there is, are we talking about personal data? Is personal data going into the training? Is then personal data being used within the machine itself? Is there personal data in the input that I'm providing? And is there personal data in the output? So we have different stages that we have to think about. And it's really important to make that distinction, because otherwise you basically end up having discussions that go all over the place. I think it would be interesting, because of the complaints that have been filed recently, to perhaps focus first on the initial phase and that phase of training. So maybe if, Max, you want to say a few words about what's been going on, and then we can maybe have a little bit of a debate.
Sure. Yeah. So on our side, we did not. I have to put a bit of asterisk. Everybody's now an expert in AI. I always say I'm not. But in general, if you look at the AI Act, it usually, when it comes to personal data, says the GDPR rules. So we can basically apply the GDPR rules in a tech-neutral way. And that's what we did so far in the cases we had. So take everything I say with a bit of an asterisk. On the training side, we basically had two cases so far. One of them was Meta, where Meta basically said they rely on legitimate interest to suck up the data of all their users to train AI. Second one that now came up was Twitter, that more or less did the same. That was against the backdrop of the EDPB, I think also taskforce report, if I'm not mistaken, on AI, where basically AI made the argument, oh, we use legitimate interest, but we just incidentally sometimes have personal data in our intake. So basically scrape the whole internet, and there may be, let's say, a news article where our name is in, and thereby we just, without really wanting it, have some personal data. And what's interesting is that the EDPB basically said that's fine but you should take precautions to not, for example, scrape social media data, because that's going to be full of personal data. So your argument that it's just incidental is kind of like a bit laughable if you take in, I say, something like, I don't know, Twitter data or something like that. And that was really interesting in these two different situations, that the latter cases, the Meta and Twitter cases, are explicitly taking in social media data, and then this analysis under legitimate interest may be a bit different. And overall, it's still a really tricky one if you can use legitimate interest for this. I think what's, for me, one of the most authoritative cases we had was Google Spain back then, where basically it was about Google scraping the whole internet for search results and doing that based on legitimate interest. And there, the Court of Justice basically said, no, Google does not have a legitimate interest. But for example, the users have a legitimate interest in their information, right to access to information, and thereby Google can actually do all of this under legitimate interest. So it's going to be interesting how all of that goes out for training data if we stay with the first stage. I hope that's somewhat of a useful overview of the litigation we had so far.
It raises one interesting point, I think, that I think is very important to bear in mind, because there's been a lot of discussion about about basically we ultimately have three groups of AI systems developers and deployers that I think are relevant, because we have those who basically have been training their systems on, let's say, just the whole internet, those that basically don't have any of their own content. Then we have those who have their own content and have been training things on that potentially, and others. And then we have those who come in kind of as an additional step. You know, if you're in the financial world, or if you're an airline company and you're trying to provide an extra tailored chatbot and so on. So then basically you're refining an existing model that's been made by someone else, and you could be doing that based on your own data as well. I think what's really important in this discussion is trying to figure out, well, how do we tackle the legal grounds issue? Because we shouldn't be, in my view, but I'm giving it some further thought. I might be publishing something soon about that. But in my view, we shouldn't be making an unreasonable distinction between legal grounds based on in which scenario you are, because otherwise we're just creating an additional layer of complexity that basically means that people don't know what they're allowed to do. And this is an area of uncertainty that is really problematic, because if we're not going to be able to deploy, if for instance, I'm not able to deploy my own version of an AI system when I might have a really good justification for doing so, then basically we have an issue, because I'm being blocked because of this uncertainty regarding legal grounds. Can I go down the consent route? Well, what if I don't have any contact with anyone? And if I don't have any contact with anyone and I can't go down the consent route, but I'm allowed to use legitimate interests, because some authorities have indicated that third-party scraping is okay based on legitimate interests in certain cases. What about those who have their own data? Are they then prevented from using third-party data? Are they prevented from using their own first-party data because they would need to have consent simply because it's possible? I think we're creating artificial distinctions that I think are problematic. And so I think we'll see in the next few weeks how basically the industry is going to start reacting to this EDPB Article 64, Paragraph 2 initiative. There will be letters of intent. I was having a panel this lunch where I was moderating with discussions from some other regulators, and they were inviting people to send letters of intent to share their point of view on an upcoming opinion before it's taken. Okay, well, I'm sure there will be lots of letters of intent where people will explain why they think a certain position should be taken. But ultimately, we shouldn't have this time pressure for deciding such a very important topic. There should be a serene discussion, in my view, between all sorts of stakeholders where we're able to come up with a common position, one that makes sense for everyone.
Willy, I know you are following closely like the work of data protection authorities on the matter, and I think we have some interesting work coming from the CNIL already that you wanted to share with the audience.
Yeah, absolutely. I think that probably the French Data Protection Authority has been the most prolific in terms of guidance on this. And actually, it pursues a positive, objective, that is providing concrete answers to the question of stakeholders regarding, the development of AI systems, which are, of course, developed and trained using datasets containing personal data. And I think that the key questions to which the CNIL is open are the following one. First, one thing that we collectively stepped over quite quickly is the applicability of the GDPR to the training of data sets. And there may be a question there. The LLM will not retain information it has learned from or linked to an individual in a retrievable format. So one may discuss to what extent the GDPR actually applies. And although it might be controversial, I think an answer needs to be given on that questions. And then with regard to, the application of the GDPR to the different phases of the training of AI, of course, the key question is the legal basis. And we all know that collecting consent in a GDPR grade way, is just not practicable. And we see already some national guidance saying that for certain legitimate interest is a possible legal basis, as the CNIL does, but the Dutch says the contrary. So it's very important that the discussion happens in a very open manner, under also public consultations, which follows a certain, I think, number of guiding principles. And we could look also at what our UK friends are doing with public consultation. There are some principles that guide them when they are carrying out them, and we should look at this with regard to AI, because this will of course have a significant impact on of course the development of the innovation and the tool that we are going to use. And this will be my last point before I let the others react. I think it's very important that authorities come back with practical and concrete solutions for making, the development of AI possible in Europe. Because the risk we face is that in 10 years, the AI tools that we will use here will not be trained, on the basis of European data. They will be trained based on language and cultural patterns from other regions of the world. If we do not achieve that balance between data protection and the development of AI, which is, by the way, allowed by a specific regulation that made it possible to happen on our continent. So finding this right balance is of utmost importance. And I think this is why most stakeholders are trying to achieve at the moment, including the French regulators. So this was, the points I really wanted to highlight today.
Thank you, Willy. Peter, you wanted to react to...
I saw Max raise his eyebrows at the same time, so I thought I'd just say, I think it's important to bear in mind the fact that the personal data issue, we have to very clearly make that distinction between the collection of information first in order to train an AI system, and then what is in the AI system itself. Whether there's personal data in there or not, I think this is a very different discussion. And so when it comes to the collection of information for training purposes, we have to start thinking about what does that contain personal data. But first we have to figure out, for that we have to look at what are the sources. What are the sources that are being selected? And can I do a selection of my sources so that basically any personal data in there might indeed be incidental? Or am I looking at a body of sources that is such that there is definitely personal data in there? I know about it. I think that is a fundamental discussion that you have to have before you get to the discussion, is the GDPR applicable? Because if you start to say, well, an LLM doesn't have personal data in it, that's an entirely separate debate compared to what is the training data itself. I think this is really important. And I don't know if Max, you want to add anything on that?
If I'm being mindful of being over the time, but at the same time, kind of explaining my eyebrow personally. And a couple of things. I think we, as Neubu, now run into new technology. Every year there's something new, and all the lawyers are like, oh, it's new. What are we going to do? We need guidelines. In reality, when we look back, most of that, we just applied the rules as they are. And I think also here, there is very good and logical results if we do so. So for example, on the personal data part, yes, there are different steps that may be personal data or not. But for example, the Hamburg DPA simply said, oh, when it's tokenized, it's not going to be personal data. And that's ridiculous if the end result is still, if you type in who is Max Schrems, it gives you basically my whole Wikipedia article. It's wonderful if that's tokenized, but if it's put back together thereafter, then I think we're pretty sure that we have personal data in the system. And that may be different for a different LLM where that's not done in that way and where you have different results. And I think there's a lot of truth in just applying the law as we have it, and then we have personal data in the training phase, maybe no personal data in the LLM, and then the input, we have personal data again. And I think as lawyers, we should be able to cope with that. What's a part of all of this is how that backlashes on the legitimate interest. One thing that we have to think about, the legitimate interest test is very flexible. And it was meant by, back at the negotiations during the GDPR, the industry was pushing for self-regulation. So they wanted to have that duty themselves to figure out how far it goes. And that's now haunting to a certain extent as well when it comes to these cases. And one problem that we ran into is it's very hard to have a legitimate interest if, for example, later you cannot comply with the GDPR rights. So, for example, if there's no option to rectify data and to delete data, it's going to be like also impacting probably the legitimate interest test at the beginning, knowing that's going to be where the data ends up with. So I think there is more, there are these stages, but then there's also certain interactions when you rely on legitimate interest. If you rely on consent, for example, that may not be the problem. And one last bit that Peter said before on first and second party or third party, I think what's also generally agreed in legitimate interest assessments is the closer you are to the data subject, the more you usually have a legitimate interest. So I would see not really the problem that you have less options to use your own data than third-party data. Usually it's more the other way around in any legitimate interest test that I'm aware of. So that may solve some of that confusion as well.
Thank you, Max. We are reaching the end of this session, and apparently the conclusion is that you will need consent for AI personal data processing. So no, I'm overly reducing what you said.
We
so
can
I
agree,
guess we will soon discuss the validity of the consent collected for AI data processing very soon. So.
I would say that consent is not the future of AI, but I mean, having this conversation on the legitimate interest makes us focus on the safeguards. And sometimes when organizations collect consent, they think that most of the work has been done. And this is why consent should not always privilege. Legitimate interest is a valid legal basis as others, and this has the interest of focusing the discussions on what exact safeguards are put in place.
That's a nice conclusion, I guess. We are over time, so I'm afraid we'll have to stop this great discussion. The chat as well was really rich, and we've had like debate on its own in the chat. So thanks a lot to the audience for all this participation. Unfortunately, because of the short time we had, we couldn't really answer all the questions. These form a great set of ideas for the next episode. So thanks a lot for everyone who joined today. Many thanks to our three guests. It was really rich, and we've had some really interesting discussions. So again, thank you. Let me wish you all a pleasant end of the day, the day at all if you're from the other side of the pond. But we'll see each other very soon. We have other episodes of these Future of Consent series coming up. So let me wish you a pleasant day, and see you next time. Bye-bye.
Thank you all.
Thank you very much.